number 1, Joshua number 2, Rachel number 3, to have a ruling on the return of plea. So in this matter, the 4 accused persons, there are 4 in this statute. The 4 accused persons, Joseph Ngwenarichim, Misha Krono, then the will. If you're right, there's something that you can. So Joseph Ngwenarichim, Misha Krono, Joshua Ngwenarichim, and that was Mandago, who shall this ruling refer to as the first, the second, third, and fourth person, respectively, have been jointly charged. Yes, with various offences as per the charge sheet in this matter. They are attended by various counsel, including Mr. Hassan and Ms. Chinga to the DPP, and that is the prosecution. A warrant for their arrest was issued on 16th of August 2023. Today, that is 19th of August, only 3 of them, that is accused number 2, accused number 3, and accused number 4 are present. All the parties there, including the prosecution, are of the view that we should commence the trial process hearing for those who are present. Yes, sir. I am of the view, after going through the legal process, that criminal proceedings, the one that I'm attacking, begins with the arraignment of accused persons charged as per the charge sheet. Yeah, charged before a court of competent jurisdiction for a judgment. So the trial being completed. Now the issue is whether this trial process should commence when one or all or some of them are not present or are absent. The guiding factor under our law is to see in the case where one of the accused persons or all of them are not present in a trial, yet whether the charge is a felony or a misdemeanor. In misdemeanors, accused person can opt to walk out or to be absent, and the court will still continue. And that person begins in the plea. And the court can waive, even in other cases in Finland, where the conduct of an accused person is not consistent with the ordinary conduct of proceedings in the matter. So I do find that the accused person has been charged together, all of them as 4, jointly in a felony. And this therefore means that their presence cannot be expected simply on account of one of them being absent. Unless, and what is unless, the prosecution in their own form can withdraw from this conduct. That it can withdraw any of them from the charge. Including by withdrawing, by way of a withdrawal or an amendment of any of them. So in short, to leave all those the issue aside, in short, I do know that we cannot commence a trial process, and the government of that the trial process begins with a plea. So whenever start making the decision, now the court starts making a decision, the court is trying the matter, and that one begins the plea process. But I'll try that plea of guilty. So they must all be present. Right? So meanwhile, in the time, application for bond. So I'll refer plea for all of them, the way it is here. But I'll get an application for bond for the one of parents. the warrant of arrest issue a settlement. We are the one to arrest the president. So, can I just move the issue? Unless someone wants to appeal, and give him the list.
Your Honor, we are obliged by your ruling. Perhaps it is prudent to seek clarification, Your Honor, on what this bond entails. Is it for the appearance of the accused persons in court, which in my view, with tremendous respect, is superfluous because they are here and you are all ready to take plea. In any event, Your Honor, bond issues should be canvassed when parties have taken plea. So from where we are sitting, we are at a loss. What is it that we have to address you on about the bond? All we can say at this point is that, and after slightly just trying to digest your ruling, is that it is prudent for us now to say, to submit humbly, that these accused persons, in the event that they are not going to take plea, then they should be held in custody until such time when this the first accused person appears in court, so that we can canvass again, or at that appropriate time, the issue of bond once and for all. Otherwise, Your Honor, we are bound now to go into piecemeal trials, because what are we supposed to say about bond at this point in time? For us, we are humbly submitting, Your Honor, that in the event that we are inclined to defer this plea, then the accused person should be held in custody until the first accused person appears.
I have deferred the plea. The plea is already.
Yes, to a date, Your Honor, which you haven't indicated to us. So we are unable, Your Honor, to address you on that aspect because we do not understand how the issue of bond. What is this bond about? Is it for the presence, for the appearance of the first accused person, or we are really unable to understand, Your Honor, what this bond aspect is supposed to be about? Because we are all ready to take plea. And in that score, Your Honor, we want to say that we are grieved by your ruling and we ask for certified copies of your ruling so that we seek redress in the appropriate forum.
Yes, we will for the second time report. Your Honor, we are of a different opinion. Our opinion is that for the simple reason that if the plea has not been taken, it essentially means that the accused person should be let go. Because on what basis are we taking a bond, Your Honor, or bail? You know, we are in court today for purpose of taking plea, but because they are unable to take plea today, we can essentially say by implication that there is no charge that has been leveled against them. They have been just arraigned in court today. Your Honor, for purposes of them being detained, Your Honor, what the prosecution is asking you is to give orders for pre-trial detention without an application, Your Honor. You know, there is no basis for which the accused persons should continue serving in custody without any form of application, without anything, Your Honor. So that, Your Honor, if our clients are cannot be released today, then we plead with the court because the prosecution has said that their hands are tied, they cannot make any application to bail and bond. We ask for free bond on all of them. If they are required to appear in a police station, they will appear. If they are required to come to court, they will come to court. As a matter of fact, they are public officers holding offices in this particular country, If at all they are required to appear, they will appear. But for today, because the plea has been deferred, they can be let go on free bond. That is what we can make an application.
Your Honor, just to add on behalf of the second, third, and fourth accused person, the prosecution has suggested that the accused person be retained. We are before you pursuant to a charge sheet. There is a danger that in view of your ruling, the accused person may be arbitrarily detained. And in this case, therefore, we wish you to clarify that they will be released unconditionally over this charge that you've defined.
What I do?
In your subsequent ruling now on the issue, you should clarify that they should not be detained or retained over the same charges that you've defined plea. Otherwise, that there is a possibility of abuse of the deferment of the ruling to the detriment of the accused person.
So can I come after and again?
Yes, Your Honor, as I had said, the issue is whether they are going to be present or not. And this deferment is Your Honor's decision.
Yes.
I think it is safe at this point, Your Honor, in time, as I indicated, to say that we are aggrieved once more,
Yes.
and in that scope, we also wish to ask for a stay of your ruling, pending revision in High Court, which we intend to go to this very moment, if possible. Because this is a novel scenario where you are all ready here to take the lead, and the court, in your own wisdom, your own decided to defer the plea for reasons which perhaps may not be sound in law, and this is why we want to ask the High Court to have a look at your ruling. The issue of free bond cannot arise because that application has not come from either the defense or the prosecution for deferment of this plea. If we were the ones prompting the court to defer the plea, for the ones who are here, then would have been asked to indicate how are we going to secure their presence next time. But this is something purely honor from the Honor's court.
Your Honor, can I say something?
No. Unless of the cuff and the agree.
No, Your Honor, there's a new issue that has arisen in terms of staying of a ruling. That did not come out. Or you did not come there? Oh, okay. It was raised. How do you stay a ruling in a criminal process? I was wondering. So,
There are issues. Okay, you can let that one. You can read it.
but Your Honor, you're saying you've not captured it.
Well, I can't remember
Because Mr.
that.
Hassan has captured and said that he wants to stay.
For paying for the appeal.
Okay. Or if the issue is
We want to be in front of the court and the party will be free. I can
not at all. If that is not an issue, if that is not the issue, then that's okay. Because I heard him say that he wants you to stay your ruling. To what end? That is what I was asking myself. Because a ruling in a criminal process.
I can start.
Yes, you have inherent jurisdiction, Your Honor, to arrest your ruling.
Okay.
Yes. The court has always had inherent jurisdiction to review, to stay, to arrest. It is decisions.
Yes, Your Honor, on that question.
The other person can respond again.
Yes, on that question, I have never seen any stay of a ruling or a judgment in a criminal proceeding. If counsel is aggrieved with the decision that you have just rendered, the only remedy is to apply for a revision in the High Court or to appeal. Those are the only remedies that are provided under the CPC, the Criminal Procedure Code. He has not raised which provision is he founding his argument on. So that what we are saying is that this court is functus officio on that question. And for that reason, if they agree, let them appeal or review, or rather apply for a revision in the High Court. That is all for on that question.
We want to rest there. We want you to continue on giving us a ruling so that we proceed. We cannot go around in circles.
So the court have just delivered a ruling on the trial process. The trial process commenced tonight. And the court ruled that the process commenced on the charge sheet, which involved all the customers, which I can't separate unless the prosecution separates them. So the prosecution had no objection in the first place to the lifting of the warrants of arrest at 2 and 3 who are present today. So the issue now is whether it is 2 and 3 who are present and the warrant of arrest having already been lifted, the concurrence of all parties hearing should be released on bond or bail at this stage, pending the arrest of number 1 or any action on the charge sheet by the prosecution there. Bail or bail is a fundamental right to everyone, even to one arrested and not charged. The fact that he is yet to be taken should not be a bar against the rules of bail. In a case where the prosecution had no objection in the first place to the lifting of the warrant of arrest which they applied earlier on, I would therefore consider that all the accused 2 and 3 and 2 and 3 who are present today will be released on bond of 2 million Kenya shillings. Not to the amount. Am I clear?
You're missing out from the fourth accused person who's also present.
There are 4.
Accused 2 to 4, so that is 2, 3 and 4. That is 2, 3 and 4. None of them. My record is not very let us try for that. That is 2, 3 and 4. None of them today. I consider them for bond of 2 million Kenya shillings, not quite a small amount, or cash for the 500,000 Kenya shillings. Taking plea and hold the arrest of the first accused person. So meanwhile the warrant was identified as on the field in force. So we are doing a date of all the rights, anybody the rights for 2 days.
John, I wish to address you at this point. I had an application in respect of the first accused person. First of all, I have had the ruling that you've delivered. And the ruling that you've delivered, yes, Mr. Yego, Your Honor. The ruling you have delivered is that the accused persons be granted bond before plea. In other words, this is akin to anticipatory bail, which is only a preserve of the High Court. I tend to agree with my colleagues that it's a novel order, but that is an order that would avail to all the accused persons. My opinion, what I wanted. Sorry, Your Honor? Yes, that's where I'm getting to now. Because my view was that what I wanted to address you last time, previously, was that you have no jurisdiction whatsoever to grant bond because the accused persons are not before you, they have not taken any plea, and by dint of Article 49H, you can only release on bond once a plea has been taken and it's pending a charge. And even the judiciary bond and bail terms at 4.2G provides that you cannot grant bail pending plea. But now that we have a ruling with us that you have granted bail before plea, I pray that that ruling do apply to all the 4 accused persons, because all the 4 accused persons have not taken any plea, and therefore there's no basis whatsoever for issuance of a warrant of arrest against the first accused person. The right to fair hearing enshrined in Article 50 of the Constitution avails to the first accused person. The first accused person is entitled to be informed of the charges facing him with sufficient detail to answer those charges. The first accused person has a right to be present when being tried, and the first accused person enjoys the right of presumption of innocence. I therefore do not understand the basis why a warrant of arrest would be issued against him, and yet he has not been given any charges, he has not taken any plea, he is entitled to his rights under Article 50 of the Constitution. Number 2, the first accused person is not a fugitive. I have explained why he is in Canada. He is in Canada. He went to Canada way before investigations commenced. As to why he is singled out among the 4 accused persons for a warrant of arrest, then for me, I would not understand that, Your Honor. By the time he went abroad, no investigations had commenced. And even when investigations were ongoing, he was never informed that investigations are ongoing. He He was never summoned to record a statement, even online, and neither was he informed to appear in court yesterday or today. Your Honor, Section 47 of the Criminal Procedure Code provides that a warrant of arrest can only be issued in case there is breach of peace. In fact, that provision goes to further provide that a court can only issue summons against an accused person if he is not present in court. I do not understand the basis then for warrants being issued against the first accused person who through me has committed to come back and plead to the charges against him. After all, as we speak, we have an amended charge sheet, which was not available at the time the warrants were issued. The warrants of arrest were issued on the basis of the old charge sheet, which has now been overtaken by events. As such, the warrant of arrest is spent and is overtaken by events. I request Your Honor that the warrant of arrest against the first accused person be lifted and the bond terms that you've issued as in favor of the three accused persons do also avail to the first accused person. I humbly pray, Your Honor.
Yes, I wish to humbly respond to counsel. In fact, I wish to thank him for speaking aloud for us as well. Your Honor, you have granted what has actually amounted to anticipatory bail. And as he has correctly pointed out, that this court is not vested with such jurisdiction. In fact, these are some of the issues, Your Honor, that we wish to now expose to the High Court when we go to the issue. Because we need to set the jurisprudence right and straight, if not for any other reason. I wish to clarify to counsel that your client had recorded a statement. I think he has misinformed you. And when we do the disclosure, I'm sorry, Your Honor. I beg your pardon. Yes. So when disclosure will be done, that will become clear. Your client had recorded a statement contrary to what counsel is submitting here. The issue of warrants, Your Honor, he is not here. The first accused person is not here. And on that basis alone, the warrants issued is valid and shall continue to be valid until such time as this accused person turns up in court. I was hoping that my learned friend was going to ask you, Your Honor, to review your ruling, because I think he stopped short of asking you to review your ruling. I'm saying this on a light touch.
Okay, he can verify. He's saying that ruling on one term is okay, but the plan also verify.
In fact, that was an afterthought, I think, because once the ruling is void ab initio, then all the consequences arising therefrom are also null and void. So it cannot be right to vest benefits to his clients as they have accrued to the other accused persons, when there's an acknowledgement that, Your Honor, there was absolutely no jurisdiction to grant the order that vests such benefits. So counsel had hoped and I was praying that he was going to ask for a review. Again, the issue may arise whether it is procedural or not. But a court always has, regardless of the technical and procedural technicalities, has inherent jurisdiction to dispense justice at all costs. Justice is not confined to certain cases. Always, Your Honor, the court has inherent jurisdiction to right any wrongs that it seems fit to do so. So again, as I said, Your Honor, we have to develop jurisprudence. Let's see what the High Court is going to decide on this. I'm most obliged. Just to point out that he had agreed that this is a novel ruling which has come from your court, Your Honor. It's a purely novel ruling. The first of its kind, I want to say, in my many years of practice. So let's see what the High Court has to say about this. That's how we develop jurisprudence.
From the application and the response is that the issue is whether that ruling of mine is in the nature of a federal way. Yes, of course, the right to appeal a regulatory person. So the issue from him and from what the country respond, what the respondent of story, is whether my ruling is in the nature of a federal way, which the commission agreed have not determined to grant. So we need to make a reason on that. Because there is another one. The right of appeal is granted, there is no problem. They have to meet the ruling.
As you please, as I said, we want to develop jurisprudence. It is important that everything is on record as
sorry,
having been submitted.
Sorry, I think what I was just saying is this. You've given two rulings. And I feel like the two rulings were by incurium, if I say so. The first ruling was on deferring the plea. The three accused persons were entitled to their rights under Article 50, sub-Article D, to have their trial begin today, because that is what the right, they enjoy that right. They cannot be held hostage by somebody who is in a faraway land. That is their right. So I respectfully submit that I may not have agreed with that ruling. But then for the second ruling also, my view was that the moment you had made a decision that they were not going to take plea, then they were not your guests anymore. You are supposed to down your tools and show them the door to leave the court premises, because they are not your guests anymore, because they've not taken any plea. The bond pending trial is what the court has jurisdiction on in Article 49 and Article 50 of the Constitution. Bond pending a plea is what in other terms is called anticipatory bail, which is normally a prison of the High Court. That is what I was saying.
I'm very sure, because this is here for long, so we need to control ourselves also. We are not here. Yes, so the issue, so what is the issue?
Mine is only one issue, Your Honor.
We met in Rosa after the ruling.
Right.
And the application, which I understood, we wanted us to extend the bond term to the other party. Of course, I've seen that happened with this issue. He had made a response on that. And he was also confused. He said, are you agreeing with that or no? Even as they're confused, are you agreeing with that or no? So from the application you made after the ruling, I should hear you also. But I can't hear forever. I can't change the title. So
my prayer is one.
Sorry. I read very well and you responded. So I'm going to frame the issue, which I'm supposed to right. Which I pronounce that is what I've made, the ruling of made, which I expected bail. And if it is the one, then you have the decision to that. Yes, so you should be there on that. Of course, you have the right to appeal, you will get appeal without no problem.
Sorry, Your Honor, I just wanted to clarify. Yes. The ruling I'm seeking from you is only one, that the first accused person, pursuant to your ruling, do be equally released on bond pending plea. That's my prayer, Your Honor. Sorry, Your Honor?
Which does agree? He said, well, yes, you have really helped me. So
Your Honor, what we've said is, that was a by the way. But because we have a ruling, and you have no jurisdiction to vary your own ruling, we will stay with it. And therefore, what we are only asking is, staying with that ruling, may we have the first accused person benefit from that ruling, and be granted bond pending plea.
So when I come back here, can I come in an application on whether to extend the loan term?
Precisely.
That's what I should be done. Yes, I'll give you the thing on now.
Yes, which again will amount to you reviewing your ruling. Because you had already made your ruling. It's asking you to review. So again, the issue is there the restriction to do so?
Of course, you have to review, but I remember very well that he had a very serious legal issue that what I have delivered amounted to a. That's why there's no thing.
Yes.
So can I make that one will have an impact on what is trying to do?
So my plea, Your Honor, will be
Yes.
have to confine yourself to that particular aspect of the anticipatory bail issue, and not whether the same terms that you have given should extend to the first accused person. Because that is a very pertinent issue, which we had actually said that
Sorry, Your Honor. I disagree with respectfully with my colleague.
Yes, Your Honor. This problem. I'm here to stand this. I'm not here to lecture people. I'm a judge. A judge gives a dispute and you go at it.
Right.
Just lecture people. So let not lecture people.
Right.
What the dispute? I'm trying to ask what do you want to do on? To do on what the dispute?
I've already submitted on. I have only one issue for determination.
Yes.
The first accused person be released on bond. That's all.
It's agreeing also now that there's no need to then for any further. I grant the bond term for the thing.
I'm not agreeing. I'm not agreeing. I don't agree that the same bond term should apply to all of them. You had already made your ruling that the accused persons who are here post what Your Honor had decided, and that the first accused person's warrant is still in force. So I have not agreed that you need to extend the terms for the ones who are here to the first accused person. It's just that by God's grace that he has raised this pertinent issue, which we were saying we were going to raise in the High Court here quietly. So you cannot again sit and review those terms. If they are aggrieved, let them join us in the High Court. Let's go together, because you have no jurisdiction to review your own ruling, which you have made. But for purposes of jurisprudence, the development, Your Honor, you can say something about that particular aspect which you raised, which would be purely perhaps for academic purposes at this forum.
I know.
Thank you.
Your Honor, just to raise an issue on behalf of the second to fourth accused persons. I'm seeing we are circumnavigating on a very simple issue, Your Honor. You have made a ruling that the accused person will be released on a cash bail of a certain amount or a bond of a certain amount. That is your ruling, Your Honor. If any other parties agree, whether you are right, yes, Your Honor, whether if you are right or wrong, that is your ruling. Any other person can take it up with the High Court. So the only issue that is remaining, Your Honor, from my analysis, is whether those particular orders extend to the first whether the warrant of arrest on the first accused person will be lifted or not. Then second, whether those bond and bail terms extend to the first accused person if the warrant has been lifted. Those are the only issues that we want. Any other issue, Your Honor, can be dealt with the High Court.
Right. Yes. That don't need to go and talk.
Yes.
Yes.
So that, Your Honor, on the question of whether your ruling amounts to anticipatory bail or not, those are questions that the High Court will determine. You cannot determine that at this particular time. You are fantastic, you know. That is a position that I am taking.
And that's why I say it could be for academic purposes. But again, Your Honor, you want to develop the students, you can say something about it. And I invite my colleague who is aggrieved by your ruling to join me in the High Court.
Apart from the I'm okay. The ruling on bond term. That one now you really need to raise it. In fact, I felt to come in here. All cash will be paid now. That is not for the court. I give the DPP the possibility the next 1 hour for that. It is possible to start on the 5th. As for the issue, the legal issue, really, let me comment on that one. There's no problem. Meeting has there's no problem. Let me be on it. What have my decision on more.
You are about to give us a date. After the ruling, you are about to give us a date. I don't know whether you're still giving us a date. I heard you are to agree on a date.
I'll give a date for the one price now. Because I want hear this. What I've ruled is that I want that be the way it is. For this person, charged with felonies, one is absent. So my ruling on that one, I thought the process begins to me. However, even when you are arrested, you can be on board by the police. Yes, it doesn't matter that you will wait for 1 year, 2 years, you do on bond, the moment they get to the police, you do on bond. If you get. So plea is yet to begin. That's my ruling. I just stand ahead. But you have the right to appeal the right, right? So let me come back and deliver my review on it. Better aspect. For a short one, then we take a date now for the one for the second so that we take plea for all of them. I also did comment there in orbital that unless the statement draw the fact that this person, that's when I will take plea to felony. But if I thought the charge would be there and misdemeanor, misdemeanor means after the case of offense, you can take plea against them. The judge is felony, you can't take plea on the absent, right? So let me retreat and come back and become a legal cleaning what is the way. Of course, the one for the second the first person that I do that will remain.
Sorry, Your Honor, you have made a ruling that the warrant of arrest subsists against my client.
I can make that one now.
Because you have promised me that you're going to write a ruling on it. Okay, so can I have leave to appeal from your ruling?
You will appeal and proceed in the next one.
Sorry, Your Honor?
You will at least appeal,
yes,
proceeding in 2 hours time. Yeah. So let's retreat. 15 minutes I come back to the day and take a date now for the plea. Then issue.
You know, this is one of my staff, is my, it's part of this team, is a council from my office. Just discussing including the option of removing this first accused person from the charge sheet, and then we can proceed. But when you come back, you might find a way about that.
We'll have a long day again.
Because as we said, you want to come back, it's straight, it's just set.
We will not have a problem if the bail and bond remain the same. That would be fine.
Let me